People versus Brisman.
Good afternoon, Your Honors. May it please the Court. Cleo Weiss for Jason Brisman. May I please reserve 4 minutes for rebuttal?
Yes.
When my client asked the Appellate Division, 3rd Department, to modify his sentence as a matter of discretion in the interest of justice, that court was obliged to consider his request and to do so using the correct standard of review. Because that court's decision reveals 2 errors in its sentencing analysis, this court should reverse and remit for reconsideration of Mr. Brisman's claim using the correct standard of review and encompassing his trial penalty argument, which does not—
Didn't we bless that language in Delgado?
So I think there's 3 differences from Delgado, and I would say that the lack of remedy in Delgado, there's 3 differences in this case that merit a different result for Mr. Brisman. One is that in this case, it's not purely using the abuse of discretion language, but the court's decision reveals that it truly undertook abuse of discretion review. The second sentence of the court's paragraph discussing sentencing says, "The record reflects that county court relied on the appropriate factors in imposing defendant's sentence." So it's not merely the repetition of an incorrect standard of review, but the fact that the court actually undertook the incorrect type of review. The second difference from Delgado that I think is worth mentioning is that the 3rd Department standard was an entrenched standard for over 50 years, whereas in Delgado you had a handful of 1st Department cases that were kind of one-off cases. And then I think the third reason that this case should come out differently from Delgado has to do with this court's recent decision.
When you say come out differently, exactly what do you mean?
What I mean by that is that there should be a remedy in this case. In Delgado, though the—
So is the remedy remit?
It's remit to the 3rd Department for reconsideration of the claims. And I think that's appropriate because in People versus—
It does not necessarily guarantee a particular result, of course.
Of course, yes. The 3rd Department could still find that Mr. Brisman's sentence was not unduly harsh and severe.
So your argument is that you want him to have an actual review of the claim that he raised.
That's correct. And the third thing that is different from Delgado is with this court's recent decision in People versus Jorge Baque, this court said that we don't look through the court's decision. And that's exactly what this court did in Delgado. It said we read that language to mean that they didn't find the—
So is Delgado still good law?
I think that the analysis undertaken in Delgado is quite different from this court's recent decision in Baque, where we sort of just looked at the language and we didn't second guess or look through to what the panel was thinking.
Going back to your first reason why this case is different, what I take away from Delgado is that a criteria such as abuse of discretion can be appropriate in the exercise of harsh and excessive review. And it's really dependent on how the court uses it, whether it uses it improperly to set up a standard to bar review or whether it considers it more of a factor or one of several criteria to use to determine whether something is an abuse of discretion. And moreover, and this is my question, if it's the latter, if it's part of just the process that the court is undertaking to determine whether something is harsh and excessive, we're not really at liberty to dictate to the appellate division what their process is. Do you disagree with that? Should we be telling the appellate division what factors it must consider in determining whether a sentence is harsh and excessive?
So this court does not dictate factors to the appellate division, but what it did, for instance, in Ba is it made clear that the fact that a sentence was negotiated is a factor among many. And I don't think this court should ever dictate a series of factors for the appellate division to consider. But what this court does is clarify that certain factors can be considered, and what this court clarifies is what the standard of review here is.
Okay, so in this case, the appellate division shows we don't see an abuse of discretion and we don't see extraordinary circumstances. 2, I don't know, facially reasonable factors that a court can use. What's wrong with their process here?
What's wrong with the process is that the legislature has provided a standard of review in 470-15-6B, which is unduly harsh and severe. And extraordinary circumstances and abuse of discretion are neither of those are a test that helps a court determine when a sentence is unduly harsh and severe. and beginning with extraordinary circumstances, that test is clearly wrong because there are many absolutely ordinary day-to-day
So
circumstances.
then we should tell them not to use those factors when they're undertaking their harsh and excessive review. Those are off limits.
The test I would have this court, or the ruling I would ask for from this court, is that the appellate divisions and the intermediate appellate courts should review whether a sentence is unduly harsh and severe, and that doesn't mean that a defendant needs to demonstrate extraordinary circumstances.
So Delgado doesn't survive this case.
Well, Delgado didn't address extraordinary circumstances. It was more focused on the abuse of discretion language. But I think Delgado, to the extent that there was no remedy, there was no remittal in Delgado, I do not think that that would be an appropriate treatment for this case. And I think that this is still a relevant issue. Of course, the Third Department has stopped using this standard, but there's a recent First Department decision, People versus Paulino, which shows that the application of this standard is still unsettled in the intermediate appellate courts. Paulino was interesting. There's a 3-judge majority who denied a modification, and 2 judges dissented from that. And the majority says, we know the right standard. We read Ba, we read Delgado, we understand what the standard of review is, but every time we modify, we find extraordinary circumstances. And I think that that shows that this court's guidance as to how to apply the unduly harsh and severe standard is very much needed by the intermediate appellate courts. And there was another appellate term Second Department case that was posted yesterday on the court reporter's website, People versus Rafael Castro. I have the citation here if the court would like it. And that court applies, again, the extraordinary circumstances or abuse of discretion language. So
Sir, go ahead.
the issue remains very relevant, and I think that the intermediate appellate courts are unsettled in how they are applying the legislature's unduly harsh and severe standard, leading to statewide disparity between how these claims are treated.
What's the distinction, or is it just semantics, is what I'm trying to understand, between unduly harsh and extraordinary? Could those not be 2 ways of saying the same thing?
I think they can be 2 ways of saying the same thing, but the reason that this court should reject extraordinary circumstances is that it suggests that there has to be something above and beyond normal circumstances. When somebody's
unduly harsh is above and beyond normally harsh. The word unduly, it seems to me, is maybe doing the same work that extraordinary is.
I think that unduly harsh and severe is what the legislature has selected, and by terming it to be only extraordinary circumstances, it leads a court to look away from the ordinary factors such as age or family circumstances or the relative culpability of somebody.
So do you have examples of what the appellate division has stated are extraordinary circumstances?
Well, focusing on the Third Department,
Yeah.
what we see when we look at cases where when the Third Department was still using the incorrect standard, in cases where they did modify, they've never, in the cases I reviewed from 2020 to 2022, did not identify what an extraordinary circumstance was. There were some cases where they would specifically find that a judge abused their discretion, but the extraordinary circumstances language would only show up in the cases where they were denying a modification. And I think that that shows that they're using it as an extra statutory barrier. And Mr. Bloom argues in his brief that the extraordinary circumstances or abuse of discretion language was a voluntary, sort of a self-imposed limitation.
I'm sorry, are they, just to go back to the cases where they have modified a sentence, they're not saying these are extraordinary circumstances?
They discuss the circumstances that lead to the modification, what merited it. They sort of dig into the details of it, but they don't say this was an extraordinary circumstance.
So then how does that show that they're using that as a bar before you can get a modification?
Well, because it's unclear for an advocate to know what they're trying to demonstrate. Can they just talk about their life and their circumstances, their unextraordinary circumstances?
Doesn't it sort of go to Judge Halligan's position that extraordinary, I mean, it's not just harsh, it's unduly harsh, so extraordinary. So they're saying that, but then when they're modifying, they're not saying extraordinary, they're saying this is unduly harsh, right?
What I would submit to your honors is that though they may seem similar, unduly harsh and extraordinary circumstances, the legislature picked a standard of review, and the appellate divisions are not at liberty.
What you're asking us to do is to say to the appellate division, you don't understand your power, right? You don't understand it, we have to correct you, and we're going to tell you now you have to do this, and you can't look at this, and you should look at this, that's what we would have to do here, right?
But that's not dictating to the appellate divisions any factors or the exact analysis they have to
No,
undertake.
it's schooling them on
Telling them
what their
The
power is.
statute says you may modify a sentence that is unduly harsh and severe. Apply that standard of review. It's what the legislature wanted.
So you don't disagree, though, that the appellate division could have said here, we do not find that this sentence is unduly harsh and severe, and left it at that?
Correct, right. Under
So
Mingo.
how does that advance the problem that you cite to this lack of understanding of what the appellate division is using? Because it seems to me that if we start, schooling them or admonishing them, the better course for them would be to just say nothing. Just say, this is not unduly harsh and severe. Goodbye.
I think that we do want to encourage the appellate divisions to write the reasons for their rulings,
But we can't make them.
but what is
But
more
don't,
important.
in a significant number of instances, the appellate division does, with respect to excessive sentence, say it's not unduly harsh and severe, period.
That's correct. Most decisions on on denying sentence modifications tend to be very short. But I think what is more important than whether the appellate divisions explain themselves and write a long opinion is that a party and a litigant knows what standard of review their case will be treated with and knows what treatment they're going to get from that court.
Thank you.
Good afternoon. Nathan Bloom for the Chemung County DA's office. May it please the court, the appellate division's broad plenary power of sentence review includes the power to review sentences for extraordinary circumstances or abuse of discretion. That's what this court decided in Delgado, and the court should reaffirm Delgado here.
So extraordinary circumstances is what they're supposed to apply for a claim of excessive sentence, and that's proper? Is that what you're saying?
I think there are two answers to that question. First, there's one argument that extraordinary circumstances, to Judge Halligan's point, simply is the same as unduly harsh or severe. It merely fleshes out.
But is it, or is it creating an extra bar for them to get a review?
And yet, to the point in my brief, even if that's true, even accepting the defendant's premise there, that's acceptable because that falls under the broad discretion that's given to the appellate.
Haven't we said that the appellate division cannot set up an extra statutory bar, a standard to the exercise of their interest of justice jurisdiction to review a sentence?
And just to clear up a misstatement in my brief, I do want to emphasize that sentence review broadly is mandatory. I misstated that in my brief, but de novo sentence review is not mandatory.
But if the legislature says unduly harsh, how could the appellate division impose an additional hurdle beyond that? That's a separate question from whether extraordinary means unduly harsh. But if you're suggesting that somehow the appellate division can treat it as a higher bar, even than unduly harsh, I don't see how that would be authorized by the statute.
I think where I'm getting that is the word discretion. I think since the
Well,
discretion.
But how does discretion may allow for some exercise of judgment, which is probably necessary, to decide whether this is or is not unduly harsh, but how would it allow the AppDiv to change what the standard itself that the legislature has provided is?
I think, as this court stated in Delgado, that the appellate division may review without deference to the sentencing court, but it doesn't have to.
I
And I
thought I
think-
heard you say that the appellate division could impose some requirement of extraordinary circumstances if that went above and beyond what unduly harsh.
I think that's what I mean, that in reviewing a sentence somewhat deferentially, in acknowledging that the sentencing court was in a somewhat better position because it had firsthand knowledge of the case, in doing that, it does raise the bar in viewing.
So your view is that the appellate division does not look at this on its own in a sort of de novo fresh way in deciding whether the sentence was unduly harsh, but should say, well, if the sentencing court thought it was appropriate, then that's probably okay?
It can review de novo, as this court stated in Delgado, but it doesn't have to. And I'm getting that from the word discretion, and I'm also getting that from the unduly harsh or severe language itself.
The word discretion, you're getting it from where?
As a matter of discretion in the interest of justice, from 470.15.6b.
So could you use discretion, could the appellate division say, in our excessive sentence review, we're not going to review any sentences that, unless they're 10 years or longer, in our discretion? Because it just wouldn't be extraordinary or excessively harsh unless it's more than 10 years.
I think to set a fixed bar from that would be arbitrary, and I think that might be a due process problem, which is independent. I think generally, if we're talking about lower sentences, that might be less appropriate for the.
Are you saying that even when a defendant requests the sentence be reviewed for excessiveness, that the appellate division isn't supposed to look at it and actually render a decision as to?
No, it absolutely is supposed to lead. It has a duty. That's as of right. But whether it reviews it de novo or
So
some measure.
discretion doesn't allow them to not entertain in the
Correct.
proper light?
Looking elsewhere in the criminal procedure law, it's clear. It does have a duty at least to look at the sentence, but
So maybe it would be helpful if you clarify what you mean by de novo in this context.
conducting a completely fresh analysis, completely independent of what the sentencing court decided.
So is the flip side of that that they must defer?
And I think, yes, and I think deference is a spectrum. I think,
So you believe they always have to defer to the sentencing judge?
no, I think they can not defer at all, as this court stated in Delgado, or defer somewhat in its discretion. And I think.
But you recognize the appellate division can, they have powers, unlike this court, to look at the facts, even if there is no abuse of discretion, and change the sentence of the
Yes,
sentencing
of course.
court
Yes,
by rendering a different decision based on how they are considering the circumstances.
yes. And I think the unduly harsh or severe language itself indicates that the court should not mandate de novo review, because on its own terms, it seems to be looking at what the sentencing court did. It's not.
But when you're saying that, the court can just look at it anew. They don't have to find abuse. They can look at it and render a sentence
Yes.
that's different from what the trial court did. So aren't they looking at it anew in that instance? No abuse of discretion, but based on the record, the sentence is X instead of Y.
I think it is possible for the court to say, were we sitting in the sentencing court's chair, we would reach a slightly different sentence, but because we're going to recognize that the sentencing court was in a somewhat better position, we're going to defer in that instance. I think that's part of the discretion that's granted to the appellate division by statute. I don't think unduly harsh or severe is necessarily a standard of review. I think it merely sets the outer boundary of the court's power as it sees fit to modify a sentence. I think that the statute is designed to empower the appellate division, and the defendant is improperly using it to handcuff the appellate division and force it to adopt a particular framework for reviewing a
But they
sentence.
don't have to. If we were to agree with the defendant, I think the defendant recognizes we can send it back. They can say, okay, we've looked at it, and the answer is no, sentence is fine.
Absolutely.
It's not handcuffing or mandating the result. I believe what the defendant is asking is for an actual considered review of their claim, even if the answer is no.
I think the record shows that the court did review the claim for extraordinary, of course, for extraordinary circumstances or abuse of discretion. and I see-
If I'm understanding you, your position is that the appellate division has the authority to determine for itself that it will only modify a sentence if there are extraordinary circumstances, because that's the only basis by which a sentence could be unduly harsh or severe. Am I
Right.
understanding you correctly?
Yes, I think one understanding of what.
Where would one find the authority for the appellate division to do that?
In the word discretion and in the,
So that means every department can decide for itself what is the baseline of unduly harsh and severe?
Yeah, I think that's by design. I think that's built into the statute.
So somebody else, another department could say unusual circumstances, another one could pick a different, what I'm struggling with is where the legislature has set out a particular standard by which this discretion is supposed to be exercised, why would we not insist that when they think about the question, they use the standard the legislature provided them, instead of substituting words that to somebody else may mean something different or may mean the same thing?
Well, I don't think that unduly harsh or severe is the standard. And
So what is it if it's not the standard?
it's simply to give the appellate division as much latitude to modify a sentence as it wishes. And if it wants to take a somewhat deferential posture toward what the sentencing court decided.
I thought it said you can modify it if you conclude that it's unduly harsh or severe. I thought that was the whole point. So that's the standard, is it not? That's your sole basis.
I think it's the goal. I think the goal of the court is
Oh,
to,
so under your view, the appellate division panel could decide it's not unduly harsh, but they're going to modify it anyway?
no, I think,
Yeah, well, then it can't be to give them as much discretion as possible, because it has to be not just harsh, it has to be unduly harsh. But that's a standard, isn't it?
I think it's, well, of course, arguably, it's the same standard as extraordinary circumstances or abuse of
Why is that?
discretion.
Extraordinary circumstance is not necessarily a standard. It's just a particular factor of the way you look at the records, not necessarily the standard.
It could be, to Judge Canataro's point.
Well, it might be.
Well, how
but they
would we
didn't-
know?
But it might be a standard, but it isn't it isn't the words the legislature chose. So I just wonder why, if we're not certain that in all cases, every appellate division justice views extraordinary the same as unduly harsh, we wouldn't make them use the words the legislature chose.
And certainly, there's no harm.
And the third department seems to have come to that realization.
Yeah, certainly there's no harm in expressly using the term unduly harsh or severe. I just don't see what is the harm in using extraordinary circumstances or abuse of discretion. I don't see how it undermines.
Is it possible that some person could view those two things as different?
They could,
Yeah. That might be the harm then.
but it falls within the appellate court's discretion, even if it somewhat raises the bar to review, because the court is,
Well, then I don't know how to reconcile it with my 10-year example. Couldn't somebody think that an appellate division justice colorably think, look, and if you don't like 10, you could take 5, you could take 3, you could take just felonies. But to say, look, in my view, it's not extraordinary unless it meets some threshold. And I'm going to substitute that for unduly harsh.
I think,
And you rest on discretion to give them the authority to do that.
So under that reading, I take it, and I think maybe you indicated this before, the first department could say, we'll look at any sentence that's, 10 years or more, and the second could say 5 years or more, et cetera, so that depending on where you were sentenced, the review that you would get from the appellate division of your sentence excessiveness would be completely different.
I'm sorry,
I took you to be saying that the appellate division, in response to the Chief Judge's question, that the appellate division can decide that it will deem something, something unduly harsh, or, as you say, extraordinary or not, that it has discretion to set different bars or cutoffs. And so if that's right, it seems to me that one department could say, well, by definition, any sentence that is less than 2 years can't be extraordinary, and so we're not going to even look at that. And the next department could say, well, for us, it's anything under 5 years, and so forth, so that depending on where the defendant is sentenced, the defendant would or would not get any meaningful review of something that the legislature has instructed that the appellate division should look at.
I think that sort of bar is different because elsewhere in the
So
criminal...
wait, so do you agree that is possible under your reading, or it's not possible?
I think Chief Judge Wilson's hypothetical would not be allowable.
Because?
Because elsewhere, the criminal procedure law does say that appeals of sentences for undue harshness or severity are as of right. So someone with a sentence of 10 years or less.
But then how can you square that with saying that the word discretion allows the appellate division to import some different standard? That, I guess,
Because a court that's reviewing the sentence with some level of deference to the sentencing court is still reviewing it in Chief
So
Judge's
we did,
hypothetical.
well, they are reviewing, they're just imposing. I mean, if you think about our decision in Apakji, right, what we were concerned about, I think, and this was an abuse of discretion, this was a interest of justice question, was we were concerned about standardization, right? That we didn't want, I think it was the appellate term in the second department, using a different standard than elsewhere.
And I think there are all sorts of policy reasons why standardization might be a good thing. I just don't think that it's required under the criminal procedure law as it is. I think it's a feature, not a bug. And if I might just pivot briefly in my remaining time to point 2, I do want to make the point that I think there's a fundamental disconnect between point 1 and point 2 of the defendant's argument. In point 1, they're arguing that de novo review is required. It has to be a completely fresh look. And at the same time, in point 2, they're saying, no, you have to look to the sentencing court and see whether they imposed a trial penalty or not. So I think they kind of undermine their argument there.
But wouldn't that go to an abuse of discretion, that standard? You could look at it and say, the trial court was wrong in what they did, as opposed to, there is no abuse, but I just want to do a different sentence, because I have that extraordinary power as the appellate division in the interest of justice to just change it, because under the facts, I believe it should be changed. I don't see an inconsistency.
I think it's inconsistent if de novo review is required. It's not inconsistent if the appellate division is allowed to look at the sentencing court, to look at the sentence with some level of deference. And that's the main thing
But
I'm asking.
de novo review saying, but you have to, I took her argument as being that in the first instance, you must review the claim.
Yes, and I agree with that. You must review the claim.
Okay.
And I think that distinguishes it from the 10-year hypothetical as well.
Thank you.
Thank you.
Counsel, could we pick up with the 10-year hypothetical or whatever bar you want to set? It seems to me that is an Apachki issue. The court is setting up a rule outside the CPL, and every case that doesn't meet that rule is gone, right? That was that case. It was an interest of justice power, but on a refiling, but they were dismissing them all. Here, I think the question is this Apachki or is this Delgado? Because Delgado seemed to say, you may have used different words, but you're applying the right standard. Will you understand your power? Apachki is, you're setting up a rule, 10 years. They didn't set up a rule that said 10 years. So why is this more like Apachki and not like Delgado?
So I think a premise for my response is going to be that the standard of review is unduly harsh and severe. And if you view the abuse of discretion or extraordinary circumstances test as a gloss on that, and Mr. Bloom argues that that's acceptable, they're allowed to do that, they can set up their own discretionary rule, I think that falls squarely under Apachki as an extra statutory barrier.
We said in Delgado, this is a way to reconcile, I think, we said in Delgado is when they used abuse of discretion, they were applying the unduly harsh and severe standard. We understand that to be what they were doing. You couldn't say that about a 10-year bar. Well, when they apply the 10-year bar, we understand that. So that's the difference to me. So why is this more like a rule that they can't set up extra outside of the CPL than it is a shorthand way to express their authority, which is consistent with unduly harsh and severe?
Because I think the end point of the people's argument here is that a court could find, while the sentence is unduly harsh and severe, we don't think it was an abuse of discretion, so we're not going to modify it. That's the end point of their argument, is that the appellate division, in their own customized interest of justice jurisdiction, can have their own test that's separate from unduly harsh and severe. But what a
We'd
defendant...
have to find that that's what we think they were doing. In Delgado, with at least partially the same language, we said we don't think that's what they're doing.
And I would refer Your Honor to the opening brief that I filed, in which I cite many third department cases, and I think that the way that they discuss that standard of review in case after case shows that it is a bar to review. and
Counsel,
that it's not-
I want to take issue with that. I was very interested in those block quotes that you gave. They're on page 28 of your brief. And when I looked at those, some of those were Apachkis. Some of those seemed to me, in context, that they were setting up some sort of extra statutory bar towards exercising of their interests of justice review. Others, to me, seemed more like Delgado, that they were just using these words as, I don't know, signifiers for what could be, or what looked like to me, appropriate harsh and severe review. So I posit to you, and wonder if you agree, isn't this dependent on a textual analysis of what the court is saying in terms of whether they're moving outside their statutory power, or they're really just undertaking their own version of harsh and severe review?
I think Your Honor is right, but I think the same result is reached either way, because this is either an application of an incorrect standard of review under Delgado and under Ba, more specifically, or it's a creation of an extra statutory barrier to something that a party, a defendant, is otherwise entitled to, and that is review of his or her sentence for whether it's unduly harsh and severe. I'd like to briefly touch on the trial penalty argument, if I may. Members of this court agreed in Ba that the fact that a sentence is negotiated is a permissible factor to be considered in sentencing review. And of course, Ba considered successful plea negotiations, and what we have here is an unsuccessful plea negotiation. But I think it follows from Ba that on-the-record plea negotiations that ultimately do not lead to a plea may be considered as a factor in evaluating the ultimate post-trial sentence. And all we ask for from this court is similar to Ba, just to, if this case were to be remitted to the Third Department for reconsideration of Mr. Brisman's claim, that contention about the disparity between the sentences may be reviewed under 470.15.6b without any preservation. And if I might just conclude briefly, we've been talking about standards of review, which is, of course, an inherently abstract legal question, but I'd like to bring it to the ground level, just for my conclusion. This is an incredibly important issue for criminal defendants. For my clients, the possibility of a sentence modification is a hope and a prayer while they sit in prison, and it's a hope and a prayer for their families who think that perhaps a panel of judges might have mercy on their loved one and they might come home a year earlier. And of course, it's very important for victims of crimes as well. The vast majority of criminal defendants raise this issue on their direct appeal, and for many, it's the only issue raised. Few defendants, of course, receive modifications, but what each and every defendant deserves is a fair consideration of their claims using the correct standard.
Thank you.